in this video, we will be starting with the Evidence Act. So we will be covering in this video, we will be covering some of the general provisions which have been given in the introductory part of the Evidence Act. So before we begin, the Indian Evidence Act came into force on 15th March 1872. Therefore, whenever we go through the bare act, it states Indian Evidence Act 1872. Now, what was pertinent to note is that during the British period, this code even applied to the, all those cases which related to the defense forces like Navy, Air Force and Army. But after the independence, this act does not apply to the court martials because, for in those regards, separate tribunals have been established and they exclusively, deal with it as per their own laws. Now, we will begin with the, some concepts that have been, given in the introductory part of the Indian Evidence Act. So to begin with, first of all, we will discuss the concept of fact. So if we take, see it in layman language, it means, it is any existing thing. It does not refer to a mental condition of which a person may be conscious. So in simple words, if we talk about fact in layman's language, it means any tangible thing. But the definition which is contained in the Indian Evidence Act and the illustrations which are appended to it, give you a different outlook of fact. It states that fact is the statement, feeling, opinion, and state of mind are as much fact as any other thing which is tangible and visible. So it also includes the state of mind of which any person is aware. Like the illustrations that are appended to it talk about that there are certain objects arranged in a certain way is a fact. That a man heard or saw something is a fact. That a man holds certain opinion about somebody, that is a fact. And, the particular man has a certain reputation, that is also a fact. Now, this takes us to our next topic, which is the relevant fact. Now, relevant fact, a fact is said to be relevant if it falls within the provisions contained in section 6 to 55 of the Indian Evidence Act. Generally speaking, a fact is said to be relevant to another if by itself or in connection with other facts, it renders the existence of a fact in issue either probable or improbable. Now the question arises, what is a fact in issue? Fact in issue are those facts which are alleged by one party and denied by the other party in a pleading in a civil case, or alleged by the prosecution and denied by the defendant or the accused in a criminal case. Now, we can understand it clearly with an example like A dies interstate. One person named D enters into the possession of his property. S, who is the other person, files a suit for possession against F, alleging that she is a sister of A. So she is entitled to get the property, and that she alone is the heir of A. D, the person who has entered thereafter, files a written statement contending that she is the daughter and the only heir of the person A, and that S is not the sister of A. In this case, the court has to decide the following thing, and these will be the facts in issue: whether S is a sister of A, whether D is a daughter of A, and whether S is the only heir of A. This is one example. So, the issues which the court frame, keeping which in mind the court can decide the outcome of the case, are the facts in issue. Like, we can take another example. A is accused of the murder of B. At his trial, the following will be the facts in issue: that A caused B's death, A intended to cause B's death, A had received grave and sudden provocation from B, therefore he caused his death, that A, at the time of doing the act which caused B's death, was by reason of unsoundness or incapable of knowing its nature. So, whenever any case is being filed, the court decides the issues, and on those very issues, it helps the court in deciding the outcome of the case. Now, this takes us to our next topic, which is the document. So, document in the layman language, it means any matter which is expressed on any substance, whether paper, stone, anything by means of letters, words, of marks. But herein, document has been enlarged after the amendment because it includes even your electronic document. Now, the illustrations that are appended to it are states that a writing is a document. You suppose you write anything, that will be a document. A map or a plan is a document. An inscription on anything on a metal or plane is a document. A caricature is a document. Now we come to the most basic provision, and which is very important, that is evidence. The Evidence Act defines evidence in the following terms. It states, evidence means and includes all statements which the court permits or requires to be made before it by witness in relation to matters of fact under inquiry. Such statements are called oral evidence. So when a witness goes and he gives any oral statement, that will be an oral evidence. And all documents, including the electronic records, produced for the inspection of the court, such documents are called the documentary evidence. So we have two kinds of evidence, oral and documentary. Now we will be dealing, I'll repeat it again for the kind perusal, that a documentary evidence is evidence which is produced for inspection of the court. And oral evidence means statement by a witness before a court in relation to the matter of fact under inquiry. Any medical report or a recovery memo, that will be a documentary evidence. But a person comes and answers the question, which is the issue of the case, that will be a oral evidence. Now, evidence can also be classified into direct and circumstantial evidence. Direct evidence means any fact which without the intervention of any other fact proves the existence of a fact in issue. For example, A is tried for causing grievous hurt to B with a club. C deposes to the effect that he saw the accused inflicting the blow which caused the grievous hurt. The evidence being adduced by C is direct evidence. Similarly, circumstantial evidence is that which relates to a series of facts other than the fact in issue. Circumstantial evidence assumes importance where direct evidence is lacking. So in most of your cases, the direct evidence will prevail, but wherein the direct evidence is lacking or there is any doubt regarding it, then the circumstantial evidence will operate. Now, in the landmark case of State of UP versus Ravindra Prakash Mittal, AIR 1992, Supreme Court 2045, the Supreme Court has made certain observations regarding the circumstantial evidence, which are as follows. The circumstances from which the conclusion is drawn should be fully established. The circumstances should be conclusive in nature. All the facts so established should be consistent only with the hypothesis of guilt and inconsistent with innocence. There was another case, Krishna Ghosh versus State of West Bengal, in which the accused persons were convicted for offences punishable under Section 498A, 302, read with Section 34. The High Court dismissed the appeal. The appeal was made to the Supreme Court on the ground that the case rested on the circumstantial evidence and circumstances did not establish the guilt. The facts were that deceased woman had died of injuries caused by the physical assault on her, whose dead body was found in her matrimonial home. The death took place within 1 year and 4 months of her marriage. The accused persons were absconding after the incident, which was of considerable importance. The injuries noticed by the witness were fit with the evidence of autopsy surgeon. The plea of alibi said by the appellant could not be established. The report of the doctor was that the death was due to asphyxia, that is by lack of oxygen, when someone chokes you and oxygen does not reaches your brain, resulting from throttling, which was ante-mortem and homicidal in nature. Now, this is all about, your concept of evidence. There is another term that we use, that is hearsay evidence. which means the statement of a person who has not seen the happening of the transaction himself, but has heard of it from others. So this, this concept of, now we can take an example, a person who has himself witnessed an accident can give an account of it to the court, but his wife who heard it from him cannot give evidence of what her husband has told her. Her knowledge being hearsay. In this connection, section 60 will be relevant, which lays down that oral evidence in all cases should be direct. Now we will be discussing the concept of res gestae and conspiracy. So the concept of res gestae has been given under section 6 of the Indian Evidence Act. Now every fact in the Evidence Act is a part of other fact. They are connected or related to each other. There is no fact which is unconnected with other facts. Now section 6, that is the doctrine of res gestae, lays down that facts which are so connected with fact in issue that they form part of the same transactions are relevant fact. The principle which is given under section 6 is termed as res gestae. Now the bare provision of section 6 goes as follows. Facts which, though not an issue, are so connected with fact in issue as to form part of the same transaction are relevant whether they occur at same time and place or at a different time and place. Now, what is a transaction? A transaction is a group of facts connected together as to be referred to by a single name as a crime, contract, a wrong, or any other subject of inquiry which is an issue. Now, we will be discussing the illustrations, some of the illustration, like, the deceased and many others were celebrating Holi. The accused fired at the deceased. Some witnesses arrived at the scene of occurrence immediately after the incident took place. The bystanders informed the witnesses that accused fired at the deceased. The evidence of the witnesses to the effect that accused fired at the deceased is relevant. Now, there was another case by the name of R versus Christic, wherein the evidence of statement was excluded by the court. This was a case of an indecent assault upon a young boy. Shortly after the incident, boy made a certain statement to his mother by which he described the offense and man who assaulted him. The reason given by the court was that boy's statement was separated by time and circumstances from actual commission of crime, that it was not admissible as part of res gestae. Because we see, if we go through the language, it states, are so connected with fact in issue as to form part of same transaction. But herein in R versus Christic, the court gave the reason that boy's statement was separated by time and circumstances from actual commission of a crime, and that it was not admissible of part of res gestae. However, it has been held, by the Supreme Court in R.M. Malkani versus State of Maharashtra, that a contemporaneous tape record of a relevant conversation is a relevant fact. It will be res gestae. In another case of Basanti versus State of Himachal Pradesh, the Supreme Court of India held that where a person suspected of murder explained away the absence of deceased by saying that he had left the village, such statement will be treated to be a part of transaction and will be held as res gestae. This section 6 is based on the English principle of res gestae. Includes two things, that is part of the same transaction. This next important ingredient is proximity of time and place. Where the transaction consists of different acts, in order that chain of acts may constitute same transaction, they must be connected together by proximity of time, place, or purpose. The test of admissibility of evidence as part of res gestae is whether act is so connected with principal facts as to be regarded as part of same transaction, and also whether it negatives any premeditation or purpose to manufacture the testimony. Now, this was about Res Gestae. Now we will be dealing with the concept of conspiracy. Now, the concept of conspiracy, it is given under Section 120A of IPC, and it is also given under Section 10 of Evidence Act. Now, Section 10 of the Evidence Act states things said or done by conspirator in reference to common design are relevant. The bare provision goes as follows: where there is a reasonable ground to believe that two or more persons have conspired together to commit an offense or an actionable wrong, anything said, done, or written by any one of such persons in reference to their common intention after the time when such intention was first entertained by any one of them is a relevant fact as against each of persons believed to be conspiring, as well for the purpose of providing the existence of conspiracy as for purpose of showing that any such person was a party to it. For instance, reasonable grounds exist for believing that A has joined in conspiracy to wage war against the government of India. The facts are that B, another person, has procured arms in Europe for the purpose of conspiracy. C has collected money in Calcutta for the same purpose. D persuaded people to join in the conspiracy in Bombay, and E has published writings advocating objects in view at Agra, and F transmitted from Delhi to G at Kabul the money which C had collected at Calcutta. And the main motive of all these people is one, because common intention is necessary, and the contents of a letter written by H giving an account of conspiracy are each relevant, both to prove existence of conspiracy and A's complicity in it. Although he may be ignorant of all of them, he may not know which persons are involved in it. And although persons by whom they were done were strangers to him, and although they may have taken place before he joined conspiracy or after he left it. This is about module 1. There is another topic which is left, which is the concept of relevant facts. Now, the relevant facts, we have discussed earlier also that one fact will be said to be relevant to another when the one is connected with the other in any of the ways referred to in the provisions of this act relating to relevancy of facts, which is given under chapter 2, that is section 5 to 55. Now, the question arises that what does relevancy mean? So as per Stephen, relevancy means connection of events as cause and effect. Relevant fact has a certain degree of probative force. This act does not give any definition of, any specific definition of relevant. It only lays down that a fact becomes relevant when it falls within the domain of relevancy. Relevancy of facts has given under section 6 to 55, and a fact which is not so connected as enshrined under chapter 2 of the Evidence Act will not be relevant, or will be considered to be relevant. Now this is all about your module 1. We have discussed some bare concepts. To quickly sum it up, what is fact in issue, relevant fact, and obviously relevancy, concept of evidence, res gestae, and conspiracy. If there are any queries regarding it, please let us know. We will answer them.